Hi, I'm Mark Small. It's Civil Discourse Now for July 25th, 2022. Still warm here in Indiana, but not quite as warm as it was the last couple of days. This afternoon on Facebook, somebody posted on the Broad Ripple Republican Club Facebook page. And Broad Ripple has a Republican club. It meets every third Wednesday of the month. I was there last week. Nobody else was. Anyways, on the page, somebody posted a photograph that included Senator Mike Braun of Indiana, and it was captioned on like Lincoln Day, okay, something like that. And I said, was that an irony? You would post a photograph of Senator Mike Braun with the word Lincoln in the caption in any way after, at the very least, the ignorant comment he made a couple of months ago at most, and what people I think generally would agree here, even in Indiana, was racist. Because he said that, well, and he kind of grinned when he said in the interview, well, that should be up to the states on whether people who have different skin color should be able to marry. That should be left up to the states, is what he said. Now, Loving versus Virginia was a United States Supreme Court case decided in 1967. It was unanimous. Now, that featured two residents of Virginia were married, man and woman married in the District of Columbia, pursuant to its laws. Then they moved to Virginia, but it was a criminal act to marry someone whose skin color was different. Actually, I think that the wording has to do with what race they were in. We're all in the human race, but not everybody recognized it. Some places they still don't today. The court, in a unanimous decision, ruled on whether a statutory scheme adopted by the state of Virginia to prevent marriages between persons solely on the basis of racial classifications violates the equal protection and due process clauses of the 14th Amendment. For reasons which seem to us to reflect the central meaning of those constitutional commands, we conclude that these statutes cannot stand consistently with the 14th Amendment. Now, I thought it was interesting that there was a concurring opinion from Justice Potter Stewart, who said, I have previously expressed the belief that it is simply not possible for a state law to be valid under our Constitution, which makes the criminality of an act depend upon the race of the actor. That's what they did here. That was common, well, certainly before the Civil War, but afterwards as part of the Jim Crow regime of laws to discriminate against people who either were former slaves or who were descended from former slaves. This is not something that varies by state. And the reason that the federal government had to interpose itself is states, some of them were glad to discriminate. They would discriminate against people on the basis of race all the time. And that is wrong. We have rights. Whether a person has a right to speak doesn't vary because that person crosses a state line. And states do not have rights. First, if you look at the Declaration of Independence, it talks about the people conveying or conferring upon government, when it's convenient, powers necessary to carry out acts for the people. Nothing is mentioned about rights. Rights are held by people. So states don't have rights. Secondly, during the Civil War, 11 of the states, I believe it was, seceded from the Union in acts of treason. The states that issued statements of secession all recited protection of slavery as a reason for them seeking to withdraw from the Union, and committed acts of treason because they went to war against the Union. Well, actually, it's a riot against the Union. It wasn't war. President Lincoln refused to recognize the Confederacy, wouldn't confer with them or negotiate with them because that would tend to give legitimacy to them. So then you have Mike Braun, who's a United States Senator from Indiana, making an incredibly ignorant statement that, well, maybe we will let it just go to the states. Really? That's not how we deal with racial discrimination. It's very serious. In these times, when the Republican Party has become an organization through which white supremacy seeks to gain power over our governments, and I say that plural, not just federal, but state. We can't just laugh these things off. We can't allow racism, bigotry, ignorance to take hold of one of the two major political parties of this two-party system. The Republican Party, last note, the Republican Party, there's no such thing as a Republican in name only. No, the Articles of Incorporation for the Indiana Republican Party is actually the Indiana State Committee, Republican State Committee, makes no mention of ideology. In the rules for the party, there's no mention of ideology. So it's not Republican in name only. If you're going to apply that to anybody, then I would apply it to people who are racists today, who advocate philosophies that embrace the Confederate flag that was carried into the Capitol, who would take away voting rights of people. All those things upon which the Republican Party was founded in 1854 and through which it fought for many decades. I'd say they're Republicans in name only because they found it convenient to grab hold of an established political party, sit their butts in it, and ride it for all it's worth because they're a minority. They're Republicans in name only. And we need to reject the notion that they have a right to rule this country. They don't. I'm Mark Smallis, Civil Discourse Now, peace, love, freedom, happiness. Now. Take care.